are here to testify on Bill 19-11, Bullying and Intimidation Prevention Act of 2011. So I'm about to call the next panel of witnesses, beginning with Nathan Saunders, who's representing the Washington Teachers Union, Rick Rosendall is the Vice President of Political Affairs for the Gay and Lesbian Activist Alliance, and Alison Gill, Public Policy Manager, Gay, Lesbian, and Straight Education Network. Oh. Okay. So now, thank you for joining us, and I do want to acknowledge that we've been joined by a member of the committee, at-large council member David Catania. And Mr. Saunders, would you like to start?
I will. Thank you very much.
If you just pull the microphone a bit closer, that would be great.
Is that better? All right. Thank you very much. Good morning, Council Chair Bowser, Council Member Catania. My name is Nathan Saunders. I'm here before you in my capacity as President of the Washington Teachers Union. As a teachers union working on behalf of students, we are in support of the Bullying and Intimidation Prevention Act of 2011. The WTU is deeply concerned about this epidemic which is sweeping the nation. Schools are intended as a safe haven for children and teens. This doesn't mean safe and orderly This doesn't just mean safe and orderly classrooms and buildings. It means ensuring dignity and respect for all. Just as we are committed to improving student learning and teacher quality, we are also dedicated to eliminating bullying and intimidating in schools. This is clearly a community issue on which we must all work together. In looking out for the safety of our children, teachers, parents, school administrators, principals, school nurses, counselors, school psychologists, and bus drivers, we all play a very critical role. Council member, I'd like to deviate from our prepared testimony and reserve the right to hand it in because as I read the legislation, it's a very important piece of legislation. And I read it last night. I had the staff prepare testimony, and I've had some experiences that I think will be of value to the committee and to this piece of legislation. I know for a fact that we have some resources in DC public schools which you may not be aware of. 3 years ago, I worked with a school psychologist by the name of Gabrielle Gannot. And Ms. Gannot was working on her PhD in an area of bullying known as mobbing, workplace bullying. And it is a form of bullying, and she's studied bullying with DC public school students. And I brought some of her work, and I went over it once again, and I did place a call to Ms. Gannot. She's no longer a school psychologist in DC public schools, but she is willing to assist the committee with regard to this type of legislation. Her work, which earned her a PhD, was as a result of direct working relationships with DC public school students and employees. And in that regard, I'd like to make some suggestions with as it pertains to the legislation. Firstly, I think that bullying and intimidation legislation definition of the affected party could be broadened just a bit. Presently in section 1A and B, it simply refers to students. Bullying happens in the schools, in other workplaces, obviously with students, but oftentimes students are emulating behavior that they see with adults. And so in that regard, I would ask you to, in the committee, to consider possibly a little broader definition of bullying and the parties which are involved. Adults bullying each other, witnessed by students, can also result in encouragement of that type of behavior by students. Nextly, in section 3, the parties involved in the policy development by the agencies named in the legislation definitely includes employees, and that is an important component. But much like I'm here today to represent the interests of teachers, I know there are other employees in these agencies that are represented by labor unions. And to the extent that the legislation specifically encourages participation by the labor unions, I think that you will have a more broader working piece of legislation because they should be involved. Right now, 4,000 teachers are with children, and they trust me to communicate their point of view on this legislation. And so if labor unions or collective bargaining entities could be specifically incorporated, I think it might be helpful and encouraging. And that's Section 3A. The word in Section 3B, which pertains to shall attempt, experiences in D.C. Public schools particularly are such that whenever this type of language is used, it gives the administrators and managers a way out. I would like to include the language, instead of shall attempt, simply state shall. These are vested parties who should be a part of the program. That's a policy requirement. It lists DCPS shall attempt to adopt policies through a process that includes representation. If we remove attempt, I think it might be helpful. Lastly, in Section 4. Section 4 deals with immunity, and it is an area in which the WTU has a good deal of experience. We believe that the immunity provision is proper. We believe also the immunity provision of this piece of legislation can and should be expanded so that immunity is not just stated, but it also should pertain to the cost of legal representation for the employee that brings forward the issue of bullying. What happens from time to time in DC public schools is that the cost of litigation can be a negative factor in bringing forward an issue, because the teacher can be held liable by the student and their family or DC public schools. And even though they from time to time can be very innocent, the cost of litigation is a very expensive component. And so those are the types of recommendations we have. I think that, once again, this is very important legislation. The WTU supports it. We have support from the American Federation at the national level, and we would like to encourage this legislation go forward with the types of modifications that we suggested. And if there are any questions, I'd be more than happy to answer them. Thank you,
Mr. Saunders. I will have questions. Mr. Rosendall.
Good morning, Chairperson Bowser and Councilmember Catania. I'm Rick Rosendall, Vice President for Political Affairs of the Gay and Lesbian Activists Alliance. We've been fighting for equality in the public schools since May 1972, not me personally, when we persuaded the D.C. Board of Education to prohibit discrimination in the school system on the basis of sexual orientation. We urged the passage of Bill 19-11, the Bullying and Intimidation Prevention Act of 2011, with the strengthening amendments recommended by our coalition of Safe Schools advocates. We thank the council members for their overwhelming support for the bill. Let us keep in mind that the district has been down this road before. What we need now is not another restatement of the city's commitment to protecting our students, but a law with teeth that will actually protect them. A key consideration is the scope of the bill. Any comprehensive anti-bullying law must apply to public charter schools in addition to district agencies that work with youth. Everyone who receives public funds should be expected to abide by public policy. If the charter schools think they are above the law, perhaps we'll have to meet them in court. That would be preferable to surrendering at the outset, which would leave a significant percentage of our students without the legal protections that all students deserve. Alison Gill of the Gay, Lesbian, and Straight Education Network, GLSEN, who is seated beside me, has the details on our coalition's proposed amendments. Here I'll summarize key points. An effective policy must enumerate the types of bullying and harassment. It should focus on the effects of the prohibited conduct rather than prohibit particular speech in a way that our allies in the ACLU have warned would risk violating the First Amendment's free speech protections. The bill should include procedures for reporting and investigating incidents, the option of anonymous reporting, provisions against retaliation and false accusations, a range of penalties for confirmed violations, publication of the policy, and a training requirement for educators and students. The bill should cover students targeted for associating with others who have the enumerated characteristics and should require each school and covered agency to submit a report of incidents to the Deputy Mayor for Education, as well as a breakdown of the specific types of bullying and harassment, including cyberbullying. The Deputy Mayor should be required regularly to publish an aggregate report. There should be penalties for teachers who ignore bullying and rewards for those who act to protect students. The bill should include the complete list of categories from the DC Human Rights Act. It is important to avoid approaches that would have the effect of punishing schools for reporting incidents of bullying. If anything, schools should be punished for not reporting such incidents. No one is helped by artificially low statistics that result from underreporting. And it is essential that individual principals with a different view not be allowed, as we've seen happen in the past, to set their own de facto policies. Without strong implementation and enforcement, even a model policy will have little effect. Success requires clear and visible leadership, inclusion of stakeholders and experts in an implementation task force, follow-through by school officials, and, of course, continued oversight by the council. The protection of all district students must become the norm. Students who feel safer will be better able to focus on learning and less likely to skip school or drop out. We owe our young people no less. Thank you.